Alex is here with the North American premiere of The Armstrong Glide, his film about Lance Armstrong. He was here last year at the festival with two films. A film he directed, Mia Maxima Culpa, and also as the executive producer of the film Venus and Serena, about the tennis-playing sisters. In the news not so long ago was a story about the U.S. Tennis Association taking legal action against the filmmakers of Venus and Serena, for footage that film had used of the U.S. Open. It's hard to make a film about tennis-playing champions without using footage from their tennis playing. That case prompted me to invite Alex to come here to talk about questions of fair use, or as it's known in the U.S., fair dealing. Here in Canada, every country has their own iteration of this rule or of this legal principle. I think also in the audience we have one of the great U.S. fair use lawyers, Lisa Califf. Lisa, are you here? Raise your hand, Lisa. Well, maybe we'll rope in Lisa.
If you see Lisa, yeah, we'll.
Yes, if we see Lisa, we'll bring her into this.
Right.
Alex, you've brought a set of clips that kind of represent some examples of this in your films. You want to set up that set of clips?
Sure. It's a good time, as Tom mentions, because we're being sued by the USTA. I should say that as loudly as Andrew said. Neville Johnson. Yes, that's USTA. They're suing us for copyright violation. And so it seemed like a good time to talk about how you use copyrighted material in a film when the copyright owner refuses to license it to you. So I think this is a very practical and pragmatic thing, and I'll try to sort of talk as briefly as possible. I just want to set up a few clips. I thought it would be instructive to show a group of fair use clips, a group of clips from films that I have done in which I fair used a variety of material, and I think the last one is Venus and Serena. So let's take a look at the clips. I'll say a few words, and then we'll get into some questions.
Did Lisa Califf come back in the room? Lisa, are you? Yeah, Lisa, why don't you come on up here and join in this conversation?
Yeah, Lisa is a lawyer, a very accomplished fair use lawyer, and anytime I say anything reckless, she will slap my hand and tell me exactly what's right and wrong.
So, Alex, why don't we just start talking about the Venus and Serena case and how this is illustrative of the bind that filmmakers find themselves in.
Sure. Well, listen, I think the Venus and Serena case is a very important and instructive example for this reason. The USTA believes that we shouldn't have the right to use this clip of Serena losing her shit at the U.S. Open because it's bad for the image of tennis. They have an image that they want to promote, and therefore they think it's bad for this image. Well, fair use is designed precisely to counter that. The idea is that the Copyright Act in the United States would be unconstitutional if it were not for fair use. So the idea is you cannot abridge free speech by using the force and weight of copyright. Which is exactly what the USTA is trying to do. And Mikan, the director of the film, went to the USTA, tried to license the footage. They wouldn't license it to her because it was bad for the image of tennis. In addition, there's an allied suit as part of this, which is that Mikan was filming with the permission of the USTA and with the permission of Venus and Serena practice courts around the U.S. Open, and the U.S. Open or the USTA has now said, no, that's our material too. You can't, we had an agreement with you. There's a dispute about that. But more instructive for the discussion today is the way that the USTA is trying to use copyright law to enforce a kind of speech that they want, and also to enforce what they see as their commercial rights. But anyway, so they've sued, and now the case is working its way through the courts.
And what do you imagine the timeline being for this? When are we going to next hear about something in this case?
We're looking for, there's a judgment coming up soon before a judge to see whether or not Mikan's attorneys, who are being paid for by errors and omissions insurance, are seeking to get a summary judgment, to basically get the judge to throw out a lot of this case. The judge at the moment doesn't appear to be that sympathetic, but the attorneys are fairly confident that either on this next judgment or further on down, they're going to win.
Lisa, over the years that we've been doing the Doc Conference and other kinds of panels around documentary at TIFF, we've had several different looks at fair use, fair dealing. And every year brings its own set of new examples. I wonder, as you kind of watch precedents that are being established, or people that are, scoring victories or seeing setbacks, what are some of the latest cases that are prominent in your mind?
Well, Venus and Serena, quite prominent. And then obviously the catfish case. We actually were the ones who rendered the opinion on that music. And that was a clear-cut case of fair use, as Andrew said before. But what's always interesting to me is there's always something else. Whenever it goes to the stage of litigation, there's usually something else. It's not just the fair use. Because especially with the organization like USTA, they have lawyers. They probably understand this is fair use. But somebody along the way got pissed off enough to actually take the measure to go and sue. And that takes a lot, because I do think that in your film, the fair use argument is very clear cut, and you're probably going to prevail on that at summary judgment. But the other interesting issue, I think, is a contract issue, which I don't even think they brought a breach of contract claim in your case.
No,
It's promissory estoppel, which is similar, but they're basically saying, you promised us you'd license this footage, and we relied on your promise, and we provided you with information, we provided you with footage. And when we have clients that do that too, and when we go along that path, we probably would have done something different at that stage. We would have said, you've engaged in a lot of conversations with these guys, and they really think you're going to license it. And whether there's a contract in fact or an implied contract, we need to talk to these guys, and we need to figure out a way to work it out. Because that's where I think the pissed off came from. And so it's always, I feel like there's always something else. There's always a political reason or something else why it gets that far. Because when you're dealing with a good lawyer, and you work with a good lawyer in New York that understands fair use, the fair use is pretty clear cut, but then is there something else there? And filmmakers have to be really careful, not just to look at the fair use issue, but also to look at any tangential issues, usually a contractual one.
One thing that occurred to me, which I should probably mention, that has come up a bunch, and it's actually come up in relation to my dealings sometimes with broadcasters. And there seems to be a misunderstanding, and Lisa will correct me if I'm wrong here, but there seems to be a misunderstanding on the part of broadcasters that there are many broadcasters who believe that it's better not to ask. If you think you have a fair use claim, it's better not to ask to license that footage because if they refuse, that's worse for you. My understanding of the law and legal precedent going right on up to the Supreme Court is that it makes no difference whatsoever. In other words, if you ask and somebody refuses to license to you, in this case, as in the USTA, that actually works in your favor rather than the reverse. And in any event, it has absolutely no ramifications in terms of the law. Would that be correct?
That's absolutely right. But where it does have an effect is the risk, because then you're on their radar. If we don't have to ask the broadcaster for materials, I typically advise not to, because for one thing, if they're providing, especially if they're providing you with masters, then it's really, to me, that is a little like, ooh, I can't get the master and then fair use it. I have to find another way to get it. But legally, Alex, you're absolutely right. It does not change your legal analysis for fair use. But from a risk perspective, you're on their radar. They're looking at you, and they know, and then they have this expectation that it's going to come, and that's where it becomes a little bit trickier, just from a risk perspective. But yeah, I do typically advise people not to go out to the broadcasters unless they have to. It also poses a problem with E&O insurance.
Not go out to a broadcaster who controls footage.
Right, right.
When Alex is referring to broadcaster, it's someone who's going to air his film.
Oh, is that what you were referring to?
That is what I was referring to.
That's
In other words,
saying,
broadcasters have an expectation that you should do exactly what you're recommending to do, which is if you think you have a fair use claim, don't go to the copyright holder, just just fair use it and be done with it.
Right.
I take your point, actually, though, some of the advice that I've gotten is if you think you can license it and you can license it legitimately, go ahead and do it. Particularly some of my masters, that is to say, either the broadcaster or sometimes the studio, prefer you to license as much as possible.
Right.
There are some cases where if you feel that, I agree with you, Lisa, that if you feel like the the copyright holder is likely to be aggressive, then don't. But very often, for example, in the case of the clip here with Enron, we went to Fox and Simpsons, and they wouldn't license it. We fair used it anyway. We went, in the case of 24, we went to Fox, asked to license it. They refused. We fair used it anyway.
And in these cases, you never heard back from them?
Never,
Yeah.
not once.
Yeah, Fox is notorious for not doing anything.
Now, there is one instance, I should say one other thing in terms of how fair use works. One thing, there had been long, from an aesthetic standpoint, as a filmmaker, I always hate the idea that I have to directly comment on a copyrighted work in order to make it viable for fair use. There are rules for fair use. But sometimes you can't do necessarily what you would like to do, or at least my lawyer advises me against it. In the case of Enron, for example, we found it to be a better cut to simply, right after that one guy who says, I'd rather be shot as an idiot rather than a crook or whatever. And then we went right to the clip of The Simpsons. And my lawyer found that risky, that he felt that we might just be dropping it again, or it might be perceived that we're dropping it in purely for entertainment purposes, which is not viable for fair use. So he recommended that we add some comment, and what we did is we put in an interview subject where the guy says, this entered the psyche of the American culture, and in that way, it puts a color on The Simpsons, which is to say that it's an example of the sort of cultural environment and how the story reverberated in American culture. And once we had done that, Bob, my attorney, felt it was viable fair use.
Yeah.
Can you talk about the international aspect of this, the sense that each country has its own set of criteria?
Yeah, so basically, I'm an American lawyer, and so we use U.S. law. Fair dealings is different in Canada. But what we'll do with our clients is we will base it on U.S. law, but we secure an E&O policy that's worldwide. And we've never had to test this, thank goodness, but our theory is that if there were a claim brought in another country, what would happen is the Berne Convention, which is the international copyright treaty, would prevail, and what the Berne Convention says is that it's a country of origins law that should apply. So if the film was made in the U.S., and even in Canada, the laws are definitely expanding and changing, that they would apply that law, and then we would be fine on fair use grounds.
So for a Canadian filmmaker, if they adhered to the laws of Canada and got insurance in Canada, the same international convention would apply.
And sometimes what we'll do with Canadian clients is we'll establish some sort of U.S. presence and get them an E&O, an American E&O application, because it's a little easier to get the fair use rider for that, and then they'll have that. And there may be even an argument that you can apply U.S. law.
Have you come up, Lisa, before with conflicts in, say, like a country in France, where sometimes, and this happened to me, with footage of John McCain right after he'd been tortured in North Vietnam, the widow of the person who filmed that footage claimed droit moral. We used it according to fair use. And the French broadcaster was extremely upset. We had insurance and so forth and so on. But tell me, what happens in that situation? It's
never gone that far. We actually had that issue with the Roman Polanski documentary Odd Man Out, where Polanski was upset and the producer of his last film was upset. And we actually just had to deal with it. We negotiated with them, we discussed the issues, we talked it through, so it never got that far. But that is an issue, droit moral, for those of you who don't know, it's an author's right. So it's a little different than copyright, but it's an author's right for attribution and for you not to mutilate the work. So you can't cut it up without their permission. And that applies in Europe, and it's an unwaivable right for Europeans, but in America we can waive it. So we have had that come up, but luckily we've never had to take it all the way.
We've got about 10 minutes. If you got questions, raise your hand. We'll try to bring you a microphone. Where's our microphone? Maybe bring it up to this gentleman first, and then there's someone in the back that we'll bring a microphone to for the next question.
Just a quick question. How about when you're faced with a situation where the insurance company asks for exclusions for certain parts? Do you go along with that, or how do you avoid making it all-encompassing, policy?
I'm not sure I understand the question.
Excellent question. Well, sometimes when you take out an E&O policy, the insurance company will say, well, we're not going to you know, you don't have the right paperwork on this, so we're going to exclude this from the E&O
Oh, right.
policy.
Yeah, my view is you have to get a policy with no exclusions.
Right.
In other words, your lawyer has to write you a letter sufficient to convince the insurance company that the material that is not licensed from copyright holders is legitimate fair use, because that's the ultimate protection, is that you have a policy with no exclusions. And I've gone down that road many times, because otherwise you're opening yourself up to tremendous
And
risk.
broadcasters and distributors usually don't take an E&O policy with exclusions on it, so you need to be really careful. And that actually goes back to the licensing issue, because there is a question on the E&O application that is something along the lines of, have you negotiated for and been denied a license? And if you click that yes, because you have, then they'll say, okay, great, we'll just exclude all that from your coverage, even if it's fair use. So that's something else we have to think about. And a lot of times with controversial docs, or docs where we suspect there may be issues, we'll get E&O really early so that we can check that box no, and then if it happens later, we're already covered, and so we're not quite as concerned about that.
Question in the far back. Go ahead, it's Bergen.
Hi, yeah. Can someone either on the panel or in the audience speak a little bit about the differences that we experience here in Canada with versus, you know, the more lenient situation in the States? Somebody's had experiences in the audience, or
With regard to fair use and fair dealing?
Yeah.
So and Tom, you may be even better to speak on this, but in Canada, the fair dealing law, what I think, my personal viewpoint is they're just not as developed. U.S. is such a litigious country that we have so much litigation on fair use. It's so well developed, and it's so clear cut that there really are specific guidelines. The fair dealing law, as it's written in the statute, is relatively similar. It's just not as developed, and I think insurance companies and distributors aren't quite as comfortable as they are in the U.S., but I think that's rapidly changing. I know there's been a lot of progress in the last couple of years with fair dealing and documentary films, and the permission to now distribute and get insurance for those types of films.
All right, we got 5 minutes. Take a couple more questions. This woman in white here, we'll grab her, and then I'll bring the next microphone to this guy in black up front. Yeah.
So two things. One is just to compare fair use and fair dealing. In Canada, with fair dealing, it's a far more conservative approach. We don't have the interpretive liberty or freedom that you have in the States, because it is connected, as you said so well, to the freedom of speech possibilities, which we don't have here. So it's only under some very strict conditions that you can avail yourself of fair dealing. The question I was going to ask is about how do you document, as a filmmaker, what kind of documentation process do you follow for those clips that you want to fair use, and how long do you keep your documentation?
Sorry, what was the first, just before, how long do you keep the documentation? What do I document?
What kind of documentation do you put forward?
Oh, you know, generally what we do is I take very careful notes, particularly with my attorney, as we're discussing these fair use issues, and rather well document precisely the logic under which we decided that fair use was appropriate. And that we put into a file that's not appended to the public file, but it's part of our ongoing log that we keep in a notebook with all of our other records relating to rights and clearances.
So is it sometimes just your own notes, or in every case, like if you're using a Bambi clip, if you're using a 24 clip, is it a letter from someone like Lisa saying, I'm a lawyer and here are the legal principles for this?
Well, usually it's part of a conversation, usually with my lawyer over the phone. So I'll take notes on that phone conversation. Sometimes it's an exchange of emails, which I'll also make a record of and keep those records so that we have some sense, because very often my attorney wants to know my view on why it is I think it should be fair use, because I'm the filmmaker, I'm the one who has a rationale for doing it. We've discussed it. He concludes that my reasoning is good according to fair use law. But that conversation is codified so that as we, you know, if it ever comes up again, there's a backup rationale for it, a series of notes in effect.
I have a question for Alex. I just want to know what happened before the complaint was filed. What was the lead up prior to that?
I think the lead up was, I mean, in this case, there was a lot of back and forth with the USTA about, you know, really you should license it to us. We're doing a film. It's a good film about the Williams sisters. It's important that we use it. We're willing to pay. We've paid license holders at Wimbledon. We paid license holders at the Australian Open. But they took a very hardline position and I think it had to do with both a rather aggressive posture in terms of wanting to control everything having to do with tennis. Also, it turns out, I believe, to have to do with their own licensing mechanisms, because they want to be able to have the airwaves clear of tennis material at a time when they're broadcasting the U.S. Open. So some of their broadcast partners, they had very specific, contractual relations with. And so they were afraid it might be seen as violating those, even though Miken's attorneys said, well, you're off the hook on that one because we can claim fair use. Nevertheless, I think what's interesting to me, particularly about professional sports, and I'm having increasing contact on this as doing a number of sports documentaries, the world of professional sports really tries to create an enclosed environment that you're not allowed to penetrate without their permission. Yeah. And so I think this was a kind of shot across the bow.
We're going to need to bring up our next panelist. Lisa, will you stay until about 1 o'clock when we go to lunch break? And,
yep.
and so if anyone wants to follow up with Lisa, you can do so in the lobby for a 1 o'clock lunch break. Is there... I don't know if there's another screen of Armstrong Glide at the festival, but it's coming out this fall. Thanks very much to Lisa and Alex. Stay in your seats. I'm going to...
Thank you all.
Thank you.